Welcome to What's the Scenario with PLRB, where we explore claims and coverage scenarios relevant to insurance professionals. I'm Brendan McLaughlin.
Hey, Brendan, I'm Mike Brode.
I'm Tim Havler.
And I'm John Hurley, coverage counsel at PLRB.
All right, John, welcome back.
All right, John, what's the scenario?
Well, today we have an named insured who is a widow and the mother of two grown children. Her daughter moved out of state, but still keeps an expensive drum set in her mom's basement. Her son still lives in the room he grew up in, but planned to move into his girlfriend's apartment by the end of the month. Unfortunately, before then, the insured dwelling catches fire, and while the son escapes unharmed, the named insured is not as lucky, and she dies.
Ooh.
Her daughter is the executrix of the insured's will and is flying in to help figure out the next steps, including dealing with the insurance aspects.
It's a sad story. Jeez, I mean, usually our podcasts are more uplifting, but
Yeah, not a fun story.
I sense we're going to talk about the death clause today. Sounds morbid.
I think John just wanted to say executrix.
I can't even pronounce it.
Yeah, that is the question. How do you pronounce that?
Yeah.
Executrix. I don't know.
Yeah.
It can be a complex situation. I don't know if any of you ever dealt with anything like this.
I did.
Family, nothing like this.
Nothing about a loss, but I did have, my mother died recently. And so we were relieved to know that even though as the named insured, she's no longer with us, that the house would in fact be covered until we were able to settle the estate. And that is precisely what the death clause in the H03 form is for. It lays out who remains an insured after the named insured dies. And this is applicable to both Section 1 and Section 2. And again, very important because without this, let's say in our situation, the named insured died and the house was damaged, but let's say the house wasn't damaged. And before you can put it on the market and sell it, a loss occurs to the house. And, so who can make a claim? And so that's why the death clause is very important, because without it, the survivors would be untethered and their future would be uncertain, and so would the coverage. So very important. So let me just read to you what the policy says. The death clause states, we insure the legal representative of the deceased, but only with respect to the premises and property of the deceased covered under the policy at the time of death. And insured includes an insured who is a member of your household at the time of your death, but only while a resident of the resident's premises. And with respect to your property, the person having proper temporary custody of the property until appointment and qualification of a legal representative can be made.
Okay, so one thing that jumps out at me there is this phrase legal representative. I'm wondering how this relates to, say, how the probate proceeding goes. Is there an official designated legal representative? Is it a more nebulous term? How are we looking at that?
Well, in insurance law, the legal representative is ordinarily the executor of the estate, so named in a will, if they have a will, or an administrator. If they don't have a will, then someone has to be appointed in order to make claim on behalf of the insured, on behalf of the premises, and on behalf of the insured's own personal property. But not everybody, you're not automatically, just because you're an heir or you're next of kin, you don't automatically become a legal representative. So it's more of a judicial kind of position, if you will. So in our situation, for example, we said that the daughter who lived out of state was the executrix. So she is the legal representative. So she can go in and make a claim with the insurance company for the damage that was done to the dwelling and any personal property of her mother's. However, she cannot make a claim for her own personal property that might have been left at the house. So we said that she had an expensive drum kit that was left at her mom's house when she moved out. She would not be able to recover for that because she is only an insured as far as being the legal representative on behalf of her mother for the dwelling and the mother's property.
Well, of course, now as legal representative, she's going to say, well, of course, my mom was a huge drum fan and wanted to play those things all the time. So, right before she passed, unfortunately, I did tell her that she could have my drum set because I left it there. So now maybe, John, maybe that would work.
Well, maybe, but the interesting thing there is what you touched on is under the policy, the personal property of an insured is covered while it's anywhere in the world, and personal property of others on that part of the residence premises occupied by an insured. So in a normal situation, if you have a friend who has a loss on your property, you can make a claim on their behalf under your policy. However, courts looking at this have held that the death clause trumps the personal property of others clause. And so in the situation of the daughter's drum kit, she probably would not have coverage if it was, strictly her drum set, even though it's personal property of others on the portion, because the insured no longer resides on the premises.
Interesting.
Now, how about the son and the son's personal property? Could the son still be an insured, and does it matter that they were thinking of moving out?
No, because he had not done so. So his personal property would still be covered. So anything that went up in the fire that was his, he would be covered for. He can't make a claim for the dwelling because he's not the legal representative, but he can make a claim for his personal property. Now, he will remain an insured until he relocates somewhere else permanently. So if he goes through with his plan to move in with the girlfriend in a month or so, then at that point, he would no longer be covered.
Interesting. I wonder, John, in that vein here, so he hadn't moved out yet, was going to at the end of the month, so we're talking, I don't know, almost a month here where he has no place to stay because the place burned down. So could he get additional living expense?
Very likely he would be able to get ALE for this. Now, some people will say, well, wait a minute, ALE is for the named insured and the named insured's household, and if there's no more named insured, how can she still have a household? But courts have looked at that, and I know there's at least one case out of Pennsylvania that held that for the purposes of the additional living expense, the you and your becomes the estate. Okay. So the son that was living in the house at the time of the fire would be entitled to ALE while the house is being repaired. Right. But again, if he decides to move in with the girlfriend, then he would be done. And if there were any other siblings, none of their personal property would be covered. And one more thing, let me just add this too. Getting back to the fact that the daughter is the legal representative, but underscoring the fact that she is not herself an insured. So she would not be entitled to ALE for the flight, to the mother's place and for getting put up at a hotel in order to go through the estate and what have you. So she would not be entitled to ALE because she was not a member of the insured's household at the time of the insured's death. Only
for this poor lady, John. She lost her mother. She had to fly all the way out there. Can't get reimbursed for that. Lost her expensive drum set. While the brother's just living large, getting all this money, living in hotels. It just doesn't seem fair to me. I guess it makes sense.
Well, I mean, the insurance is meant to keep up what was going on just before the loss. Before the loss, she was not in the picture. She had her own household out of state. He was a member of his mother's household. And therefore, he could make that claim that while they're repairing the dwelling, that he would be entitled to anything additional living expenses in that regard.
All right. Makes sense.
Okay, so it sounds like this whole thing is meant to be kind of a temporary thing to just let the family get their affairs in order and give them temporary coverage during that time. But I'm guessing at some point, coverage is going to formally end under the death clause. So what is that point?
Well, it would end when the estate is settled. And again, that's why the legal representative comes in and can handle things on behalf of the named insured who died. So once the estate is settled, then the dwelling is no longer covered. And I'll give you an example, a little twist on the scenario here. Let's say that the named insured dies, but there was no loss at the time of her death. And the executrix and her brother legally then deed the house, the residence premises, to themselves. And once that's done, then there is a covered loss to the house at that point. Can they recover under the policy? And the answer is no, they cannot.
Ooh, I was going with yes. Why not, John?
Well, because they deeded the house to themselves. The insurance follows the personal interest of the named insured and not the property itself. So once they deeded the property to themselves, the estate, all in effect, as far as the house goes, was closed. It's like a new owner, whether they're family members, it doesn't matter. So the coverage would end at that moment. So if they didn't immediately get coverage for themselves once they deeded it to themselves, they'd be out of luck in that case.
So they just have to buy their own insurance now for the place.
Right.
And she can get her drum set covered then, right? There you go.
Then the drum set would be.
Yes.
All right. Yeah, thanks for covering this, John, because, it can be really complex to get an estate settled. There can be probate issues, finding the right copy of the will and figuring out all the parties involved. So it sounds like a great way for, insurance companies to provide these people with some peace of mind in that kind of tricky period.
Right. I think that's exactly what it is. It's the peace of mind that they don't have to worry that they fall, between the cracks if something were to happen in that case. And so the policy lays it out. And again, it's Section 1 and Section 2.
So, John, what can we take away from this scenario?
3 things I think that we would want to take away. One would be that the policy does not terminate upon the death of the named insured. That's very important and the primary reason for the clause. The second one is that any relative of the named insured who was a member of the named insured's household at the time of death would continue to get coverage for their personal property until they move out or until the estate is settled. And that would very probably include ALE. And finally, only the legal representative can act on behalf of coverage for the dwelling and for the named insured's personal property. So in our situation, again, the daughter is the executrix. She could come in, handle the coverage for the house, handle the coverage for her mother's personal property, but her brother would be on his own. And the brother, as not the legal representative, he could not make a claim on the house or his mother's personal property because he is not the legal representative, even though he is an insured and was residing in the house at the time of her death. So it gets a little complicated that way, but when you read it all together, it really solidifies pretty much all the actors and the scenario of who will be covered to make sure that everything's fair, that there is coverage for the dwelling and the insured's property, as well as any other person who qualifies as an insured.
Can I actually clarify that real quick? So
Sure.
If the brother had personal property, he would need the sister to step in and make a claim for it on his behalf. Is that correct?
No, I'm sorry if I was confusing there. No, he makes it on his behalf because he's an insured. His personal property is covered while it's anywhere in the world, as long as he still remains an insured. So under our scenario, anything that burned up in the fire that's his, he makes a claim. He's covered. But the mother's personal property, as well as the dwelling itself, is up to the legal representative, who in our case is the daughter.
Gotcha.
Okay, Mike, where can an adjuster go to learn more?
Well, plrb.org. Of course, check out, there's annotations, policy annotations around the death clause, which are fascinating. We also had a cool coverage question in there that does the death clause prevent an insurer from canceling the policy? So research and check that out. And then, case law review, insurable interest lost when the executor transfers property to self, which kind of John was touching on during the scenario. So that's another cool document that you can find in the Legal Hub with your friends at plrb.org. Brennan, you'll share all that stuff in the notes, right?
Yes, and there you'll also find a recap of the key points from this episode and links to our social media. Don't forget to subscribe and rate us, and please give us a call at 630-509-8704 and leave a voicemail to share your adjuster story. we'll see you. Hold on, Mike. Do you have any questions for me?
Of course I do. Anybody call yet? Actually, John called and left this message about this death clause, and that's why he's here today, right?
Correct.
There you go.
So there was our first call, allegedly. But we could use more.
Absolutely. Yeah, give us a call. That's 630-509-8704. Or if you're on YouTube, just go ahead and leave a comment there. That's fine. But either way, we'll see you next time.
Bye, everybody.
The views and opinions expressed in this resource are those of the individual speaker and not necessarily those of the Property and Liability Resource Bureau, its membership, or any organization with which the presenter is employed or affiliated. The information, ideas, and opinions are presented as information only and not as legal advice or offers of representation. Individual policy language and state laws vary, and listeners should rely on guidance from their companies and counsel as appropriate.